Okay, we can start.
Thank you, Gustavo. So, hi everyone. Thank you again. I think I'm talking here in behalf of CELA. It's a great honor again to have both Professor Callisto and Professor Angela here to speak about competition policy in developing countries. They are both experts in competition law in their home countries. Professor Angela, our first speaker today, is professor at the University of Hong Kong and the director of the Center for Chinese Law at the same institution. The center promotes dialogues between China and the rest of the world. Before joining the university, Professor Angela taught at King's College London and was a lawyer in the US, Europe, and Asia. She holds her LLB from King University and her LLM, JD, and JSD from the University of Chicago, where she wrote her doctoral dissertation under the supervision of Judge Richard Posner. She's also the author of the recent book, Chinese Antitrust Exceptionalism, where she analyzes how China is reshaping global antitrust regulation by the way China regulates and it's regulated. Our second speaker and in-house professor is Professor Callisto Salomão Filho, competition law professor at the University of São Paulo Law School. He is also professor at the Institut d'études politiques de Paris. Professor Callisto holds his LLB, PhD, and post-PhD from USP Law School, and he also holds a PhD from the Università degli Studi di Roma La Sapienza. He is the founder and director of the Law and Poverty Group and the academic director of the Luiz Gama Clinic for Human Rights, both at USP Law School. He is also an academic member of the Institute for Global Law and Policy at Harvard Law School. Our event is structured as follows. First, Professor Angela will present the main aspects of competition law enforcement in China, exploring how and why the Chinese policy is so different from the mainstream. After, Professor Callisto will discuss competition policy in Brazil, comparing it with the Chinese experience. After that, there will be a round of questions between the professors. And finally, the audience will ask questions to our guests. Sorry for taking so long. Professor Angela, the floor is yours.
Thank you very much for inviting me. It's a great pleasure to speak in Brazil. And it's actually my first time ever to present any of my work in Latin America. So it's a huge honor and I'm very happy to be here. I will speak for about 25 minutes based on the slides I've prepared. So I'm going to share with you my screen. Okay. So my talk today will be based on my new book just released in March entitled Chinese Antitrust Exceptionalism. Now, when I said China is exceptional, really derives from this chart here, where you see there are clear power imbalances between the government and the businesses, where you see the government clearly has the upper hand. Now, this has implication as to how China regulates, as well as how China is regulated. Now, in terms of how China regulates, because there is a near absence of judicial oversight of agency actions, because companies very rarely challenge the agency. So as a result, the whole administrative enforcement process is more or less internalized within the bureaucracy. And so that's the reason why bureaucratic politics dominates the regulatory enforcement process. And that's also explained why I actually devote the longest chapter to discuss bureaucratic politics in Chinese antitrust enforcement. These power imbalances between government and businesses also have implication as to how China is regulated as a target for antitrust regulation, because Chinese companies also actively engage with other countries, right? I mean, they sell to, they're one of the biggest exporters to many countries, and they also invest very heavily in both developed and developing countries. So they have inevitably also become targets for antitrust regulation. But then when foreign regulators started to scrutinize Chinese companies, they are often confronted with a difficult question of, how do I assess the scope of these Chinese companies? Because, should I see them as like an individual firm, or should they be deemed as part of a bigger China Inc.? Because of the difficulty to answer this question and to assess the independence of the Chinese firms, this makes the Chinese companies very vulnerable to foreign regulation. Okay. Now, how China regulates, as I argue in the book, has implication as to how China is regulated. As you know, in the past few months, a regulatory storm has blown into Chinese tech sector, where you see the Chinese government has taken a very heavy-handed approach to regulate its tech firms. So the greater control the Chinese government has over its companies, be it state-owned firms or privately owned firms, this might give rise to further suspicion from foreign regulators about the independence of these companies. Now, on the other hand, how China is regulated also has implication as to how China regulates. Because if foreign regulators takes a very aggressive approach in regulating Chinese firms, or is specifically targeting Chinese companies, then this might prompt China to retaliate and take measures against foreign firms operating in China. So that's what I call, in the last section of last part of my book, regulatory interdependence between these two. So let me start with how China regulates. Now, in early April this year, Chinese Antitrust Authority announced $2.8 billion fine on China's largest e-commerce company, Alibaba. And you see here the press release from Alibaba that the firm did not plan to challenge the agency. Instead, it thanked the regulator for the penalty decision. Now, contrast this with what you have been familiar with in Europe, where Google is fighting tooth and nail with the European Commission and EU court, right? I mean, it's determined and is indeed appealing all three of the decisions by the Commission. Now, Alibaba's case is not exceptional. In the past, whether we're talking about big American companies or European multinational firms, they all behave similarly, right? I mean, you see here the Tetra Pak's response to the penalty decision of the Chinese Antitrust Authority, that we are disappointed with the decision, but we decided to accept it and do not intend to appeal. Now that raised the immediate question that why don't you bother to appeal if you are disappointed with the decision, right? Now, some of you may say that's very easy to understand. We all know that in China, maybe also the same case in Brazil, that in order to do business, do well in China, you need to maintain good relationship with the Chinese government, right? I mean, so if you challenge the antitrust authority, you might burn the bridge with the government. Now, what and by the way, but that doesn't kind of reconcile with what's happening in China recently. Since 2014, you see a significant surge of the administrative litigation appeals in China. So these are the cases appealing against the government agencies, because in 2014, the Chinese government amended its administrative litigation law that makes it significantly easier for plaintiffs to file suits in China. But we haven't seen a parallel trend with Chinese antitrust enforcement. So that further raised the question of why these firms don't challenge. Now, what I propose in particular highlight in this book, although I don't exclude other explanations, is that the Chinese Antitrust Authority are very good at using media strategy to entice firms to cooperate and to deter them from defining defying the agency. And let me give you one example here. So in 2013, the NDRC, one of the three former antitrust authority, announced on the Chinese Central Television that they had been investigating Bilstein and a few other infant formula manufacturers for antitrust violation. And the next day, sorry, it looks like it's my computer freeze a little bit. Okay, the next day, the People's Daily, which is the party's mouthpiece, announced the name of a few more companies that were involved. Now, but curiously, there were 3 more companies that were involved here, but they were not mentioned in the CCTV news or the Chinese newspaper. So it appears that in this case, the authority exposed the companies to 3 different levels of publicity depending on their cooperation with the agency. So Bilstein, actually a Chinese company, initially tried to defend itself. And that's the reason why the authority actually exposed this firm to the most negative media publicity. And as a result, this firm lost over 1/3 of its market capitalization within 1 week upon the announcement of the investigation on CCTV. Okay, so even if this firm ultimately also received a severe fine in the form of antitrust sanctions, but that fine is minuscule as compared with the market sanctions that it received from this strategic shaming sanction. Now, on the other hand, those companies that quickly cooperated and provided the documents that were needed by the authority were rewarded with generous leniency. And here I show you an executive from Wyre, one of the infant formula manufacturers that were investigated at that time. And he went on the CCTV show along with a group of Chinese antitrust officials and saying how he cooperated and submitted all the documents that was requested to the antitrust authority. And his firm ultimately received 0 fine from the investigation. Now, similarly, in this round of the law enforcement campaign against Chinese big tech that I was talking about, we saw that this kind of strategic shaming strategy was applied again. So on December the 24th, which is the Christmas Eve last year, the Chinese Antitrust Authority put out a 1-sentence announcement that they have been investigating Alibaba for the choose 1 from 2 business practice. Now, 10 minutes later, we see the Chinese People's Daily put out a long commentary endorsing this decision. So presumably this, it looks like that that announcement and the commentary has been well prepared in advance. And the commentary was there to shape the public discussion about this case. Now, let's look at how the market reacted. On that day, Alibaba's stock dropped over 13%, wiping out over 1/3 of its, wiping out over $100 billion market capitalization. So Alibaba is one of the top, used to be one of the top 6 internet firms in the world, okay? So it's kind of parallel to companies like Facebook, Amazon in terms of market cap. It's not that different. But because of this investigation, this firm's stock prices since the beginning of the antitrust enforcement campaign until now, it has dropped over 30%. So you see how much negative impact this kind of law enforcement action has on the Chinese tech companies. Okay. Do you have any questions so far? Okay. So now seeing what what just happened might give you the impression that, wow, the Chinese authorities are so powerful and they are never challenged, so they should be free to do what they want. And just the opposite, Chinese administrative officials actually operate with very severe bureaucratic constraints. And as I show you here, like, I mean, they're like this little dancer here that they can only dance within a very small stage. And the reason is because of this phenomenon called power fragmentation within the Chinese bureaucracy, because each agency is in charge of a specific area of regulation. And so, and inevitably, when there will be some overlapping duties among different authorities over specific regulation, whether we're talking about over a company or over a specific industry. And that actually imposes constraints on authority to act. And so that's what I call the Chinese style of checks and balance within the bureaucracy. So despite the fact that we don't have this kind of external checks and balance, as you observe in Western liberal democracies, there are Chinese styles of checks and balance within the bureaucracy. And that is part of the bureaucratic constraints that Chinese agencies have faced. Now, the Chinese antitrust enforcement in the first decade is an excellent example of that, where you see the enforcement responsibilities of antitrust is split among 3 different enforcement agencies, right? And each of these agencies has very different mission, a very different culture, and a very different structure. As I elaborate in the book, that all these things will have a very big impact as to how they enforce, how they form the enforcement agenda, how they approach different cases, and how they ultimately decide a case. Now let's come back to the law enforcement campaign against Chinese big tech. We see that after the Alibaba's fine, the Chinese Antitrust Authority, along with other market regulators, summoned 34 tech firms for an administrative interview. And we saw after this interview, all these 34 firms vowed to comply with the regulatory demands. And interestingly, they all released public statements as one is released here. One I posted here on the slides. This one is from JD, which is a fierce rival of Alibaba. And you see from this statement that these companies vow to improve compliance, not just with antitrust, but with various other market regulations. Like for instance, JD vowed to improve compliance with consumer protection law, e-commerce law, advertising law, price law, in addition to the antitrust law. And all of these laws actually fall within the enforcement mandate of the ministry, the SAMR, which is where the antitrust bureau was housed in. So it appears that this SAMR, this ministry, is trying to leverage the antitrust function to enhance its regulatory control over big tech in various other aspects of the regulation. So that development reinforced what I was saying earlier, that an agent's missions and culture and its structure will have an important influence on how it will shape its enforcement. Now, let me shift to the international arena and talk about how how China is regulated has had an impact on how China regulates. So as you probably have heard in the news that Huawei and ZTE have been subject to a lot of US sanctions since the Sino-US trade war. And also Huawei CFO Meng Wanzhou was arrested in Canada upon the request from the US Department of Justice. So all these cases have prompted the Chinese leadership to become worried about the US long-arm jurisdiction over the Chinese businesses and executives. And they were scrambling to decide, what kind of countermeasures that we have, what kind of laws that we have that allowed us to launch a counterattack against US firms. And then they have found antitrust, right? I mean, so the United States has been holding up supplies to Huawei, right? I mean, has been trying to cut off supplies to Huawei to undermine Huawei's business. And as a result, China has been holding up all these mergers relating to the semiconductor industries for fear that if the US companies keep buying or become even bigger in semiconductor, it will make Huawei sourcing even more difficult, right? Now, in addition to holding up mergers, the Chinese authority, also not the authority, you see the Global Times, which is the party mouthpiece, actually released a commentary after the US further heightened its sanction against Chinese tech firms that it might apply, among other laws, the Chinese antitrust law to investigate US companies like Qualcomm, Cisco, and Apple. So as Sino-US tension intensify, we might see, antitrust become a weapon for trade and national security purpose. Now, in the last part, I will talk briefly on how China is regulated as a target for antitrust regulation. I will first start with Europe. And here this chart shows you since the financial recession in 2008, there is a very large influx of capital coming from China into Europe. Okay, and most of this money were from state-owned firms, and that makes the European Commission kind of concerned. Are these companies Trojan horse of the Chinese government, or are they seriously, independent firms that are investing in Europe? Now, in 2016, when EDF, which is a French state-owned firm, partnered with CGN, which is a Chinese state-owned nuclear power company, to build a joint venture in Hinkley Point in the UK, as I show you here, the Commission decided for the first time that it will see all the Chinese state-owned firms in the energy sector as a single entity. Now, this has a very big impact on how on the merger assessment, right? And create a lot of uncertainties for the Chinese investment in Europe. But interestingly, also give rise to headache for the EU, because if the EU sees Chinese companies as one single firm, then presumably the Commission should not have jurisdiction over mergers or cartels among Chinese companies, because these will be deemed internal activities within the firm. Right. So actually the Commission's kind of a broad approach actually also could potentially jeopardize its own jurisdiction over Chinese companies. And that explains why the Commission has been exploring alternative regulatory tools to deal with Chinese investment. And its most ambitious proposal came just last month when it released a draft regulation that would tighten the anti-subsidies regulation. So it will scrutinize more investment that has been subsidized by foreign governments. And many believes that this proposal is specifically targeting at Chinese state-owned firms. Now, similar dynamic has occurred in the United States, where there have been a surge of cartel litigations against exporters against Chinese exporters because of the concern of the trade dominance from China. And the most famous case is the case involving a group of Chinese vitamin C manufacturers. And this case went all the way up to the US Supreme Court. So the Chinese manufacturers did not deny that they have fixed prices, but they argued that they were compelled by the Chinese government to do that, because if they compete, they will risk selling it too low, that they might be subject to anti-dumping duties. So that's why the Chinese government imposed export restraints on these companies, but then that makes them vulnerable to antitrust litigation, right? So you're seeing here this kind of dilemma of the Chinese firms. If they price too low, they will be subject to trade sanctions. If they price too high, they could be subject to antitrust violations when they sell in foreign countries. So, and their lack of independence with the Chinese government actually make them quite vulnerable to this kind of regulation. So At the end, I would like to just draw one implication of this book on globalization. In the past couple of years, the relationship between China and many other countries have rapidly deteriorated, particularly with the Western countries, right? I mean, so in light of all these tensions, do we still have any good prospects for globalization? So obviously, my book did not paint a very rosy picture of China's rise and its impact on the antitrust regulation. However, I do conclude my book with an optimistic outlook that I believe that globalization is inevitable because given now, even if Western countries have very little trust with the Chinese government, right? I mean, so how do you still facilitate cooperation? But we see that, if the Chinese government can hold hostage of Chinese companies, foreign governments can equally hold hostage of Chinese companies. And this is a trend that's quite obvious in the past few years. If you think about companies like Chinese companies like WeChat, Tencent, whose WeChat was threatened to be blocked in the United States, and TikTok, right? I mean, which is owned by a Chinese tech giant ByteDance, and that was almost blocked in the United States, and as equally Huawei, and all these companies now operate at the mercy of the US and European countries, right? I mean, so Chinese companies are also held hostage by Western governments. And this kind of hostage exchange, I believe, is actually a good thing because this is precisely those commitment divides that are conducive to cooperation and peace. On the other hand, if foreign governments continue to block Chinese investment, then in the future, they will have less leverage over China. And that actually makes their operations in China more vulnerable. And with that, I would like to end my presentation and very much look forward to hearing Professor Calisto's comments and experience in Brazil and your questions.
Thank you very much, Professor Angela. Your presentation, I think, I'm speaking on behalf of all, it was excellent. And I'm forwarding the Professor Calisto to hear you.
Thanks, Gustavo. Thanks, Professor Angela. That was your presentation was very clear and interesting. I won't speak for long. I'm just going to draw some comparisons from the Brazilian system. And in drawing these comparisons, have in mind that antitrust is not the only tool to discipline economic and market power. And different countries have in different moments used different tools. Actually, even in the presentation of Professor Angela, it was clear that antitrust is one of the tools that's used. Even there in antitrust, it's not necessarily through antitrust instruments that firms are compelled to comply with regulations. So, and that I have developed in some of the academic work I've written and published, is that, look, the study of market power and of economic power goes far beyond antitrust. That's the first statement that we have to have in mind. It involves sometimes patent law. It involves other times even corporate law, because there are different ways for you to curb market power. You can curb it from the outside through antitrust law. Sometimes you can curb it from the inside through corporate law. Sometimes you curb it or you discipline it through patent law, because the patents are the most relevant legal instrument that the companies have to dominate markets. So it's fine we speak about antitrust law, but let's have in mind this broader picture. Look, market power, market domination, its discipline goes far beyond antitrust law. That's my first point. My second point would be the following. I think my second point is to compare kind of our realities. So what's the difference between what is happening in China and what's happening in Brazil, which is not an easy task because obviously there are many differences in economic history, in culture. So it's not an easy task. It would be necessarily superficial. And a third and short part would be how we look into the future. What are our perspectives? So a comparison between the realities. 2 points here. First, historical one. Well, there are things, maybe there are more things that divide us than things that are in common, especially our economic history. Look, Latin America and Brazil are economies are kind of defined by their colonial history. Why? Because those of you who have been to my classes have heard that too much. I'm sorry to be repeating myself, but monopolies have existed in our colonial history before the society and before the states existed. Where colonies were not independent states, and we had monopolies, the metropolitan monopolies from the metropoles, right? Well, you could say that's far away in the past, but the problem is that it profoundly influenced all of our institutions, and even the state. When the states are born in Latin America, they are born out of these monopolies. Professor Angela does not know it, but we have a term for our initial governments that's called governos café com leite, milk and coffee governments. Why? Because the main oligopolies that were the producers of our main economic products were the ones that dominated the government, were the first presidents, the first governors, the first representatives in the House of Representatives, and so on and so forth. So monopolies have been dominant for centuries in our region, in these ex-colonies, because they came here first, so to say. What does that mean? It means two things regarding our reality. First, that they are in a sense, I don't know to which extent, it would be interesting to compare that with Chinese reality, but they are in a sense more far-reaching than others. I normally speak of triple draining effect of monopolies in our realities. And now I'm speaking about now, right? Let's stop that. Let's put history into its place now. We have the influences of our economic history, but let's see how it is now. Well, one of the main consequences of this deep enrootment of monopolies in our society is that they have a much bigger effect than we normally think of. And what is the triple draining? Well, first on consumers, that's the standard effect of monopolies. They have a huge power on consumers. They have always had. Second, on the labor markets, they are really, really powerful. Now that the unions are overall in the world fairly weakened, they have even more powers. So they nominate even the rates of employment. Every time you hear about a measure, the following day you hear about how many people will be unemployed by this new conglomerate group. So, and so they have this second draining effect on the labor market, and the third draining effect on other sectors. Why? Because you have dominant sectors and dependent sectors. Our famous economic historian Celso Furtado spoke about that in Brazil you had, since the colony, dynamic sectors that were those of agriculture and minerals and some others, and all the others were dependent. And it's interesting for a foreign observer that it's not a case that our agricultural and mineral sectors still dominate our exports, right? They are almost, represent almost the vast majority of our exports. Well, these were the sectors that were the monopolized one by the metropoles, and that were the only ones that were, in the word of these economists, dynamic, had an internal dynamic of their own. And they dominated and they drained the others. That's a problem that still lingers in our economy. So many traces of our present history are a product of our past history. And what's the meaning of that for antitrust enforcement? The meaning is that we have kind of I'm overstating now. Look, all antitrust agencies in the world, they are between two powers, right? The governments and the private parties, the monopolies. They are pressed by both of them. They try to be kept. Both parts try to capture the antitrust authorities. From Professor Angelo's discourse, we gather, at least I gather that, and that's the impression we have from China in general, that the most important pressure or capture in China comes from the government. In Brazil, for these reasons I just briefly mentioned, and there would be a long way to discuss all the ways that has been used by market power structures, private market power structures, to capture our authorities. In our reality, the most oppressing one, the most oppressing kind of capture comes from the privates. Why? Because of all this economic history. Well, if you had monopolies before you had the state, obviously they will be the most influential power. Well, how this works in different ways. It works creating institutions that protect themselves. The process of the creation of antitrust authorities and the antitrust environment is heavily influenced by privates. We had, since the 90s, the creation of a very well organized and very sophisticated group of antitrust lawyers for big enterprises that come and go from the authorities, from the antitrust authorities, in the sense that there is a revolving door there. Prominent economists that once worked for firms go to CADE and come back, or they go to CADE first and come back to private firms. Lawyers, the same thing. So the first institutional, I wouldn't say the first, but one of the institutional creations that helped that was exactly how the antitrust institutions, and especially the ones that are involved in the antitrust discussions, were created or were raised or were allowed to come and go from the antitrust authorities in these revolving doors. The second is obviously the influence over the government. Well, differently from China, historically, government is more dependent on firms than the opposite. So if they cannot, if not for these revolving doors, they, in different times, and I would have many examples regarding that, when we were faced with relevant mergers that should be addressed, should be disciplined, should be considered, and maybe not permitted by our antitrust authorities, there was direct pressure on the government to influence the antitrust authorities to approve them, and they were approved. So the consequences of all that is that over the years, and there is a very interesting graph in a very, I always mention it because it was very well done, in a very well done empirical study by one of Professor Carlos' students, doctoral students, Rodrigo Fialho, where he shows that since the introduction of our new model of antitrust law, let's say European-like model of antitrust law in the 1994, our merger control has been, over the years, more and more willing to approve almost everything that is submitted to the agency. So instead of being more stringent, instead of being tougher on antitrust, for any reasons, as Professor Angela showed, in China, there are political reasons for doing that. But instead of doing that, we have been more and more reluctant to discipline in any sorts, to discipline in any way structural movements or mergers, to discipline and prevent in any way mergers in our economy, because CADE has been more and more reluctant to that, in this to do that. So in this research by Rodrigo Fialho, he showed that actually we are close to zero regarding the cases that have any relevant measure imposed to the companies that are merging. You have some measures, but they are not relevant. So this is the state of affairs, and I'm sorry if I was, but what I try to show is our state of affairs is the following. It's historically dominated by monopolies, and we see this historical domination, this colonial domination, having its effects until now. And so, again, our problem is about the opposite of China. It's not too much influence from the government, it's too much influence or capture from the privates. Well, what to do about that? First of all, so now we've seen the reality, let's talk about what could or should, and in some ways it's starting to be done. First of all, a theoretical remark. No country has really been able, that's again a thesis that I've discussed for years and written in papers and books that I've published. There's no country in the world that has really entered into a development path without curbing structures of power. Maybe to say no country is too much, but let's say in the opposite way. Countries that really entered this development path, they sooner or later, they were obliged or compelled to curb market power, because market power does not allow for development, because again, it has this draining effect. It wants all profits. It wants to concentrate all wealth, and so on and so forth. So take the example of the US. The big development phase of the US starts when they start to curb market power through different structural measures in different periods of time. We can say that in the 20th century, every 50 years, they are applying structural measures to divide companies. So you have the Standard Oil case in the beginning of the century. Then you had the famous ATT cases in the middle to end of the century. Now you start to speak about curbing big tech power, and that's what the Biden administration seems to be on the way to do. Take Germany, for example. And again, here I come back to my point. You don't necessarily have to curb market power through antitrust measures. There are different ways to curb it. There are different ways to discipline it. There are different ways to limit it. What Germany did after the World War II was destroyed. Monopolies had been a relevant part of the Nazi strategy. So they curbed, even military, they divided the companies that had helped the German regime, and they introduced a corporate law. A change in the corporate law, limiting the power of shareholders and putting and giving power to the workers, the so-called co-participation law that now are so relevant, and it has been recognized by economists has been so relevant to German development. Take China now. Professor Angela may correct me, but in the eyes of foreigners, we see the policy, not necessarily the antitrust policy, not mainly the antitrust policy, but the policy introduced by China after the 90s of obliging firms to share technology with Chinese firms, to enter the Chinese markets, the famous joint ventures that were obligatory, as a way to curb foreign market power and to say, look, we don't have access to the technology you have, we want to have. If you want to come to the Chinese markets, you have to try to divide, to share your technology with us. That was one of the reasons why, in the opinion of many, my included, China entered the path of development. We have not done this job so far for the reasons I tried to state in the previously. Well, we are dominated by these monopolies still. They capture many of our institutions. They help shape our antitrust culture. So what are the prospects for the future? And it's interesting that I'm going to finish in a similar way, differently with the instruments, but in a similar way to Professor Angela. I see globalization as a tool, but not because Brazilian authorities can counter-coup as Chinese authorities can, and Professor Angela showed it to us, but because globalization can help us to get, or at least to limit, this power of this monopoly power, this internal monopoly power that dominates or captures our authorities. And again, I'm exaggerating things, maybe, but it's clearly the capture here. The main capture comes from the privates and not the government. So what are these perspectives? Well, first, let's say some positive words about Brazilian environment. Our antitrust laws are very good. They are modern. they have, because they were discussed in Parliament for long, during 20 years of changes, of innovations, they have institutes that can be well applied and have been well applied in the cases of cartels, for example, leniency agreement, so on and so forth. They have included some of these problems that I mentioned to you, some of the problems related to the triple draining they have had and still have, in my opinion, because of the Constitution, provisions that protect the workers against both mergers and antitrust misconduct, that protect other sectors from the triple draining. So remember the triple draining on the consumer market, on the labor market, and other sectors. We have provisions in our constitution and antitrust law that could help us deal with that. So our antitrust law are fairly good. The problem is the application. The problem is the influence and the capture over the agencies. So what's the clear path here? One of them. Well, there are two. First, we will have one way or other to curb market power, if not through antitrust, through some kind of discipline. We are trying to do that through patent law. We have had a positive decision now from our Supreme Court regarding the extension of patents. That's relevant in Brazil because we have many foreign patents. So this was a relevant curb of market power. But we must do more. And how can we do more? Through globalization. What kind of globalization? Bringing Brazilian antitrust claims to foreign courts. And how we do that? We are doing that. There are relevant cartel cases that were trialed in Brazil by our antitrust authorities, but would take very, very long to reach the indemnification phase, meaning to get the damages parties to have indemnifications from the cartels. What we are doing, we are bringing those claims to European courts because many of the defendants, many of the cartels are international companies. So we bring that to the European courts, we apply Brazilian law. Europe, because of the Rome II Treaty, because of Brussels recast regulation, allow us to apply Brazilian law. So we bring that to foreign courts. We have a famous case now in England that's in the newspapers this week. 1,500 orange producers are have filed a case against some of the biggest orange juice producers in the world in England, applying Brazilian law. So if we are captured by private parties, if it's difficult to comply with our good antitrust laws in Brazil, we export our antitrust laws, right? So it's not the long arm of Brazilian antitrust authorities, but I hope in the future, Professor Angela, the long arm of our law that might be applied now, at least in Europe, to chase the cartelists that cause damage in Brazil. So again, to conclude, you see that our pictures are different. You see that our realities are different. But you see a common thing. Along with Professor Angela, I see that I see that the world is interdependent, and it will be very difficult to find solutions for the environment, for market power, for different fields of the law without either cooperation between governments. That's what Professor Angel thinks will happen, or if not cooperation, at least interchange of jurisdictions. If not cooperation, if not only cooperation, also litigation throughout different jurisdictions. That's the path that Brazilian law and Brazilian reality seems to be following now. And that's a path for the future. Use the globalization tools to be able to apply the laws, to be able to curb market power, to be able to create interdependence. But that's it I had to say. Thank you for your attention, and I'm eager to hear and to discuss with Professor Angela and you. Thank you.
Thank you, Professor Calixto. It was a very good presentation as well. I would like, before the round of questions between the professors, to forward to Professor Carlos and to bring some other insights to our discussion. Professor Carlos, the floor is yours.
Thank you so much, Gustavo, for organizing it. And thank you, Professor Angela and Professor Calixto, for the excellent presentations. I think we speak in the name of all of the coordinators of CELA when I thank you for your time and generosity to speak with us today. And my question would be to both of you. I think when you both spoke, I think we saw very clearly this new understanding of us having a kind of a variety of antitrust regimes around the world. We have here Gustavo Castrupi, who's studying comparative antitrust regimes with the Republic of Korea. And we have found many interesting counterintuitive issues as a result of his research efforts in the last few years. And I think your presentations also show that. I have to confess that I've never seen Professor Calixto so optimistic about Brazilian antitrust law. Usually we get more the idea that Brazilian antitrust law follows this long tradition that started with Brazilian anti-slavery trade laws in the 19th century that were then described as laws for the Englishman to see, laws in the books that would not translate in action. And as Professor Calixto mentioned, the research of Rodrigo Fialho kind of demonstrated that, you know, the antitrust law in Brazil is kind of a misunderstanding. You know, it really is not applied. And yesterday we had news that I never imagined we would have, like one of the first cases in which we had a merger case that was rejected by the antitrust authority in the 90s was the head of the Brazilian antitrust authority mentioned that they were considering reviewing it, like about 20 years later. Like those are things that we would never imagine would happen. But I was joking with Rodrigo yesterday that his thesis is named like the discontrol of antitrust law. And this would be like the discontrol of antitrust law, you know, twice over. And those things are really unbelievable. But my question to you would be, considering this kind of variety of antitrust regimes, and that you already were kind of geared in that direction, we have seen since like the last G7, we have seen an effort from, you know, some of the largest economies in the world to control at least the big tech companies and control them. First, what is very clear is that, you know, there would be reforms on tax laws in the major countries to control certain loopholes that were devised by these large contemporary monopolies. But considering, you know, the changes in the antitrust policy in the US that we might see, I would not think of it as impossible that we would have a proposal for the creation of some kind of a convention, an international convention on antitrust, or some kind of international multilateral organization regarding antitrust. My question to you would be, would you be in favor of like such internationalization of antitrust law?
Would Professor Calisto want to respond first, or I'm happy to weigh in first?
You go first, Angela. You go.
No, in the 1990s, there were a time when lawyers and scholars have very fierce debate about whether we should have an international antitrust law. But the reality is that after years of debate, it never happened. I mean, there were some proposals on the table that might be this could be part of the WTO and could be negotiated. But eventually, this idea just flopped, and there was no follow-up after that. But if you look at the Chinese experience, right? I mean, there are quite some striking parallel between antitrust and IP enforcement in China, and that do raise a very legitimate question. If IP enforcement, IP law could be internationalized, where countries, like China, need to comply with TRIPS obligations, whereas antitrust, in the field of antitrust, China is not obligated by any sort of international obligation, and that is precisely the reason why you see the Chinese administrative authorities were afforded with so much discretion, and the Chinese government can wield its antitrust against foreign firms, right? Because there's no institutional constraint from within or from outside, right? So if you apply that logic, then it does seem to make sense for other countries, at the very least, to want to pressure China to join some sort of multilateral organization so that there can be international consensus and basic standard to promote international antitrust, whether in regard to the regulation of big tech or other things, right? And now, whether China will be willing to join will be another matter. It depends on what China can gain from such a deal, right? I mean, in the TRIPS deal, I believe that developing countries were willing to give this kind of commitment to improve protections, IP protections for foreign businesses in their home jurisdiction because they were granted with better market access and lower tariffs in other countries. So they got something in return as part of the bigger negotiation of the trade deal. Now, query with this dysfunction of the WTO right now and the Sino-US trade war ongoing, whether there is any clear prospect for China to realistically join a bargain with other countries, particularly with the United States. But I do see potential there that, if we can achieve something like an IP, why couldn't we do it with antitrust? And because seriously, that's why, in antitrust, it's almost like the Wild West. There's no constraints to do anything. Yeah.
If I add to that, first of all, there's Carlos, your question is a very good question. As Professor Angelo said, in the 90s, there has been some tries to do some kind of unification. I think international unification of antitrust laws is not possible. There's a difference between unification and essays or a try to globalize. Let's try to explain that. And I think the comparison suggested by Professor Angela with TRIPS is an interesting one. Look, well, there is a TRIPS treaty, it's right, but there are two things that are specific in this case. First of all, we have a whole range of flexibilities, especially to developing countries. So you can apply differently the unification, these laws. And second, and most compelling, and here I don't know if I think that if I'm convinced that intellectual property is a good comparison, because actually, at least for maybe less for China, but because China had already got the technology through their means, through the compelling joint ventures. Although they had accepted patents, they forced the companies to do a joint venture and share technology. So they've chosen another path to get access to the technology. But for China, and maybe for India in certain circumstances regarding drugs, our experience now with vaccines for COVID is a disaster. I mean, the unification, the partial unification of intellectual property laws led to a disaster in the Southern Hemisphere. We don't have access to technology. People are dying much more. People will die much more. There are news now that the pandemic is ravaging Africa, and we knew that would happen. They don't have access to the technology. So if they want, we've paid a high price, and we are paying a high price for TRIPS. So from the Southern Hemisphere lenses, I would say that unification, even with safeguards, is not a good idea. Well, maybe to have some kind of a globalization in the sense of a small set of principles that could be unified. And I think that's what also Professor Angelo was talking about. A small, very small set of principles that could be recognized by all countries, much smaller than the TRIPS, much smaller than the TRIPS. And for the rest, let's have globalization. In the sense that I'm saying that I've described it, not something unified, not something built from the upper side to the bottom, but bottom up. In what sense? Well, you compare the different laws, you are eager to apply a foreign law when a company is domiciled in your country and has caused damage in another country. So my preference would be, and I think this is the most realistic scenario, I'm with Professor Angela, I doubt that many countries would the differences in power realities and market power realities in different countries are too big for the law to be unified. You can have a very small set of unified principles maybe in the future, and for the rest, you have to build a global law in the sense that I just mentioned, through case law, through big and relevant cases, and have in mind a big case has an effect on the market, a non-repetition effect. Companies learn that they cannot go there and cause damages in other countries, in environmental damages, antitrust damages, because they will be trialed either there or in their own jurisdictions. So I think global law has an important role to play, maybe more than unified international law.
Thank you very much. This was great. I would like to ask you, Professor Angela, if you would like to present a question to Professor Callisto, or if you both want to have questions from our audience. I know that we have some questions from our audience from YouTube. or if you want to have questions from our audience here in Zoom. Sorry, Professor Angela, I think you are muted.
Yeah, I'm mute. Yeah. I would like to first thank Professor Kelechi for his incredibly insightful and thought-provoking comments on my presentation by comparing with the experience in Brazil. I have to admit that I have given quite a number of book talks before, but this one is probably the one that I benefited most because I heard and I learned a lot from a country which is actually have almost the polar opposite experience as China. As I show you in the first slides, that when there is power imbalances between government and business, that also exists in Brazil, but it's just the opposite, where you see businesses seems to have the upper hand. And the professor's comment are so good that, and he actually broadened my horizon because I mostly write about antitrust law. And he used historical perspective and a very broad developmental perspective that encouraged me to think about other areas of law that could curve market power, like patent law, corporate law, labor law, tax law, right? I mean, also related to the German example after the World War II. And I think all this, because I'm just super grateful that he pointed out these points, and I jotted down them in my notes because I think they're incredibly important for us to think about the ongoing and important issues regard to how to regulate big tech. Because as you see, the debates in the United States mostly focus on antitrust, but there are other things that we need to think about, and that could potentially and also work in tandem with antitrust law. And so for this, I'm very much grateful, and I do seriously think that these are very important points, and that really provoked me to think about actually need to look broader than antitrust to analyze these issues. And I'm happy to take questions from the audience.
Thanks, Angela. Let me tell you that I thought your presentation was very interesting too. And in academia, as you know, I hope the audience will understand, in the true academia, we like to discuss and debate. So Angela, I propose to you an exchange of books. What you just mentioned is written in a book by me in English. Gustavo, if you could put if she is interested, if you could put the reference to her. And I would like, and I would very much like to have your book. I will try I think it's published by an international house. So we could continue this exchange. I hope we continue this exchange, which is very interesting, through looking at what we've written about that. And I would be happy to do this. So Gustavo, if you could please exchange the references of the books, I think we could continue these exchanges. And I would love to have the reference to Professor Angela's book. I just saw it on the screen, but I don't have the reference.
Sure, Professor. Of course, I will send these references to both of you after our panel. So I would like to ask you, to our CELA students here in Zoom, and also to our other guests here, as for example, Rodrigo Fialho, one of the researchers mentioned by Professor Calixto, who is here with us, and Vitorido, one of main researchers here at USP as well. If you have some questions to Professor Angela and Professor Calixto, please feel free to join to our discussion.
Hello, I have a question actually, but Vitor, you can go first. I see your hand.
No, go ahead. Go ahead. Please go ahead.
Okay. My question is regarding the goals of antitrust. Since we're talking about antitrust in developing countries, I would like to ask both of you a kind of common question in the debate, which is, do you believe that we should have a same goal for antitrust in developing and already developed countries? Should the goal be the same, or should developing countries have different goals when using and applying antitrust?
You always go first, Angela. You have
Okay. You raised an excellent point, right? I mean, in the case of China, for a really long time, China promulgated its anti-monopoly law in 2008. And one of the major driver for having this law, despite the fact that China have a very large state-owned sector that almost dominate the economy. So there was a very long debate regarding whether China needs to have an antitrust law at all. But eventually China did have an antitrust law precisely because of the concern about foreign competition and about foreign monopolies, right? I mean, so if you think from that standpoint, then it does seem that from a developing country standpoint, they might want to apply the antitrust law strictly to discipline foreign competitors to protect their own industry. Now, in the Chinese experience, now if you look at our tech sector, we didn't really use antitrust law to discipline foreign tech firms, but we just completely block their access to Chinese market with the Great China Firewall. And as a result of that, we have fostered really large tech giants that are paralleled to US tech companies. Like we have companies like Alibaba and Tencent that are among the top 10 largest tech companies in the world. And we don't have Facebook, in China. So the Chinese government does not need to worry about Facebook's influence and potential manipulation of public opinion in China. And if you look back from the hindsight, it seems like, this China strategy of blocking foreign competition, even if not necessarily with antitrust in that example, but with a more straightforward and heavy-handed approach just to block them access completely, does seems to, allow the room and the opportunity to foster national champions. And so, if we think about the counterfactual that China did not block these companies to come into China and embrace them with full arms, just look at what is happening in Europe, right? I mean, Europe has no big tech giants, and Americans dominate the whole European competition landscape. Then query whether China would still have, Alibaba and Tencent as it have done today, right?
Thank you.
Rodrigo, I think the aims cannot be the same. And interestingly, the aims have not been the same through history. Look, that in different moments in time, countries, and indirectly Professor Angel is saying that, in different moments in time, countries have chosen different aims in antitrust. Took the US law. Take the US law. But until the 70s, it was one goal: to curb market power, to apply in an intense way antitrust. Then it comes the Chicago School, right, Professor Angela, Posner, Bork, and the like. Why? Because they want remember the initial days of the influence of the influence of the Chicago School. What they said, well, there are these Japanese giants that don't apply antitrust law and that are dominating the market, the big auto industry at the time in the 70s. So the aim of our antitrust law should be different, should be to promote efficiency. So from the 70s on, the US starts, because it wants to compete with the world, to promote efficiency, not so concerned with a stringent application of antitrust in the sense of fostering competition, as it had done until the 70s. So they change within countries. Imagine between countries. China, when it needed to attract companies, it did it through its joint venture law, but it protected its own companies from not applying too much antitrust during many years. So goals of antitrust vary not only between countries, but within countries in different times. That's very important. So what about different economic histories like the Northern Hemisphere and the Southern Hemisphere? I think we are still on the stage of having to curb market power, of having to apply competition in a strong sense. We are not in the stage of trying to promote any kind of efficiency or things like that. So I think there are different goals in antitrust law. And again, that's why I think there are different goals in antitrust law, as there are different goals in patent law. That's why TRIPS, well, first of all, has to be written the way it was. And second, has the problems it still has, because there are completely different goals between the Northern Hemisphere and the Southern Hemisphere. It's the same for antitrust. So again, I come back to Carlos' question. If we are in the future to try some kind of unification, it has to be very, very limited to general principles. And for the rest, we need globalization.
Thank you very much, Professor Angela and Professor Callisto, and also thank you for the citations regarding my thesis.
Thank you very much. I think we have two questions, Victor and then Caio.
Oh, okay, thank you very much. Thanks, Professor Angela. It's a pleasure to have you with us at the University of Sao Paulo. I've been following your work quite substantively, so thanks so much. So I actually would have kind of it's two questions in one. So the first refers to this idea of transparency and the forms of intervention of the Chinese state. So from your presentation, you have referred to numerous different tools that the Chinese state can actually deploy, not only those related to antitrust, so financial regulation, direct participation of the state, via shareholders or state-owned enterprises, indirect negotiations that are not published. So I'm just wondering if you would sort of have reasons for the Chinese state to focus on the anti-monopoly competition narrative. Is there a particular role in deploying those instruments, apart from the legal impact, of course, but from the rhetorical point of view? Why would the Chinese state decide to deploy anti-monopoly resources instead of, for instance, just directly pressurize via indirect negotiations with CEOs of companies, or just enforce their rights in case of companies that are partly owned by the Chinese state? And then the second question refers to the impacts to developing countries. You have very interestingly mentioned the interface between the Chinese antitrust authorities and EU North American authorities. But what about other countries that are under the direct influence of China, really thinking, for instance, of Southeast Asia or Central Asian countries, which do not necessarily have the same leverage as the US and the EU in trying to enforce their anti-monopoly laws in a way that sort of counterbalances the pushes by the Chinese state. So, so the second question would be whether there would be an imbalance when this sort of clashing model is applied beyond Western states. Thank you very much.
Victor, it was really nice to meet you, and you raised very interesting and very important questions. I can answer your second question first. You're absolutely right that when I thought about the book, that I was more thinking about China and the West regarding the EU and the United States, because these are the big powers. Regard to the smaller countries, to begin with, these countries would not, like the US, aggressively impose sanctions on the Chinese companies. So, and without provoking China, I guess they would not, need to retaliate against China. That said, if you look at the experience of Korea, there was a few years ago when Korea installed a missile defense that prompted the Chinese government to retaliate with a lot of administrative measures, including closing, including a lot of this kind of administrative investigations into Korean companies, curbing Korean imports into China. And so that causes a lot of damage to South Korea. And your point does, you do raise an alarm for smaller countries, unlike the EU and the United States, who have leverage to deal with China, right? I mean, if you look at the South Korea experience, the country do, suffer a lot when it provoked China, although not with regard to trade issues, but more like a politics and a military issues. Now, with regard to the first question, the Chinese government nowadays no longer directly intervened into or micromanage its businesses, be it state-owned firms or private firms, because the whole institutional settings have changed. Unlike before, the government under the planned economy, the government do operate businesses. Nowadays, all this administrative authorities were abolished, right? I mean, so all the decision makings, the business decision makings were left to the businesses. Now, even we're talking about state-owned firms, as much as foreign critics have suspicion over these state-owned firms, for the most part, they do enjoy a lot of autonomy in running the business, and that's quite deliberate because the government do want to give them the freedom to do that in order to encourage these companies to compete and become a fierce competitor in the market economy. So when the government wants to discipline these companies, they do need to rely on legal tools, and antitrust is one of the most potent weapons at the disposal of the government. And obviously, the Chinese government also have other extra legal tools, like the media, which is what I mentioned in the presentation, right? I mean, this media is an incredibly powerful governance tool by the Chinese government to cause reputation damage over a company. So you can see, in some, it does offer the flexibility as well. Depends on how the government want to criticize and or to praise a particular company. So media offer quite a flexible, a very supple tool for the Chinese government as well.
Thank you very much. It's great.
Thank you. I know we have reached our time here, so I would ask you, Professor Angela and Professor Callisto, if you have time for two more questions from our audience. I think it will take a few more minutes. Thank you. So please, Caio, the floor is yours.
Yeah, first of all, thank you very much, Professor Angela, Professor Callisto. It was really a privilege to be here with Stella in this morning, China evening. And it has been a very insightful meeting regarding the role of antitrust in developing countries and considering the case of two very different countries such as China and Brazil. Regarding the presentations, we could see that the dynamic of the interest in China can be used as a tool of international trade. And in Brazil, our greatest worries about is the competition inside. Regarding my question is for Professor Angela. Regarding the state-owned companies in China, which probably dominates the market, along with some major private companies such as Alibaba. My question is, the fragmentation of the bureaucracy works as check and balances in the Chinese style. And from what I read in an article prepared by professors at Columbia Law School some years ago, usually the state-owned companies are concentrated, their manager concentrated in an agency of the government called SASAC, State-Owned State Assets Corporation or stuff like that. But we know that there are some state-owned companies that work in the same sector as other Chinese companies. For example, there's a lot of automobile companies, as we can see here in Brazil. They compete with each other. And we know that some of these companies are not controlled by the central government, but some province, like the Haitong Bank, is controlled by one province in China. I don't remember which one. Here in Brazil, the antitrust is more concentrated in regulation. The competition inside the country, especially among Brazilian, are very well established foreign companies here. What about China? How does this competition among Chinese companies that belong to the same sector, especially when they have different controlling shareholders, even though they are all state-owned, how this dynamic of competition is regulated? It is through antitrust law, it is through reserve of market, or it is through administrative or negotiations inside the bureaucracy?
Right. I mean, that's an excellent question. So in China, we have a very large state-owned sector. At the central level, we have about 100 essentially state-owned farms, and these are the mega farms that operate in the most strategic and important sectors in China. And whereas at each level of the Chinese government, whether we're talking about the provincial or the city or municipal governments level, there are also state-owned farms, right? I mean, and China had 34 provinces where you have, millions of state-owned farms at each level. They do compete fiercely with each other. And even among these 100 also Chinese largest centrally state-owned farms, they do also compete fiercely with each other. And that's explained why recently the Chinese government has orchestrated a series of mergers between the largest centrally state-owned farms. And one of the reasons is to help to foster the competitiveness of these largest companies so that they can be more competitive when they compete overseas. But on the other hand, the Chinese government also imposed very strict regulation on these companies, being aware that they are becoming the monopoly in the Chinese market. So they do curb their power through very strict sector, almost like sector regulations, very strict price regulation. But on the other hand, whether that kind of regulation is effective is another story, because as our Professor Calasto has mentioned, right? I mean, this kind of regulation could also be subject to capture, so there are a lot of problems there. For the most part, antitrust law was kind of absent in the regulation of Chinese state-owned firms. It has been applied before, but the agency was met with severe bureaucratic resistance. And so, for a small bureau, they would rather spend their resources in targeting the largest, foreign companies, where presumably they are faced with less bureaucratic resistance. Yeah.
Thank you so much, Professor Angela.
Thank you, Caio. And Daniel?
Good morning, all, and thank you both professors for the most thoughtful presentations. My question, I think, is a little bit a combined question of Rodrigo and Professor Portugal, is in that perspective, but in the opposite direction. You both said that antitrust law can be used to curb or instigate forces of market. So my question is, do you think there is any antitrust regime, national regime, that the goal is to attract foreign investors to a country or to be more friendly to the entrepreneur? And if so, we can call today or in the future a war between different national regimes of antitrust law, like battle for more attractable and friendly to the entrepreneurs antitrust law. And I think Angela and Professor Calasto can answer that. I want to see both perspectives. Thank you.
Okay, great. I mean, that's a very interesting question. But I think from a foreign company standpoint, when it decide whether to enter into a market, regulatory environment is one of the factor that they will consider, but it's not the dominant factor, right? I mean, so for companies, foreign companies that want to access the Chinese market, they are looking at a 1.4 billion population, that vast and very deep and vibrant Chinese market. That will be the first factor on their mind. When they enter the Chinese market, they know the regulatory environment could be hostile and could be unstable, and it could be risky in China. But nonetheless, there is a trade-off to be made, that, this is the market where they can potentially gain a lot. Just look at Tesla, which recently opened the largest factory in China, and Tesla stocks, jump very sharply, very dramatically in the past few months and in the past year, because of the support from China, that they are able to ramp up its supply in China, right? I mean, so you could say, these foreign companies, foreign banks still flop to the Chinese market despite, all this potential obstacles that they think about the antitrust law or other administrative laws, hassles that they have to deal with in China.
I agree. Now I will turn to the pessimistic guy that Carlos is used to see, and that he was kind of surprised not to see this time. Daniel, to repeat what Professor Angela said with stronger words, in Brazil, people really don't care about the big enterprises really don't care about antitrust law to enter the market. And I doubt, look, maybe for a merger they will ask their lawyers about things, but I don't think there will be a competition for firms based on antitrust between countries in the future, because again, companies look for markets, as Professor Angel said, now for, and this is worse, now for environmental regulation, the lower and the less stringent is the environmental regulation, the more they go to the country. Why? Because since natural resources is one of the inputs that the company might need, if it is for free or with low regulation, they will prefer the country. So there is a kind of a flow to the bottom here, which is very worrying. And I think here we should think about having unified principles and global law regarding environmental regulation, because this is dangerous. So they look at the market, they look at environmental regulation, they look at tax, they don't look at antitrust. Seeing your question from another perspective, should governments make them look at antitrust? So to say, give them incentives through antitrust law? I don't think so. I think antitrust is something that must regulate the market and not necessarily attract investors. So I understand your question, but I don't think either that it is a tool used now or of any effect now, at least not a big effect in Brazil. And I don't think it should be a tool used to attract investors. We have better and worse tools, you know. Better tools, tax and things like that, and worse tools, what's being done now, low environmental protection, which is very, very dangerous. But that's how the game is being played now.
Thank you.
Thank you very much. I think we've gone beyond our time here. And so again, I would like, on behalf of CELA, I would like to thank you very much, Professor Angela, especially because it's late night there in Hong Kong. And it was a very great experience to hear about Chinese experience and the Chinese exceptional way to regulate antitrust. And also the debate on the Brazilian experience from Professor Callisto's standpoint, it was a very great and possible way to discuss it. So I would like to thank you and invite you to speak here again whenever you can. Thank you again, Professor Angela and Professor Callisto.
Thank you, Gustavo. Thanks, Professor Angela. It was very interesting to be with you here and all of you today. Thanks.
Thank you very much again. I thoroughly enjoyed the book talk. I hardly noticed time have passed by so quickly. And I learned a lot from Professor Callisto and the audience today. And do send me the reference Professor Callisto's mentioned. That would be the first thing I would check out early next week.
I'm doing this after our panel here. So thank you all the audience for having you here. It was a great honor for CELA. And I'm inviting all you to our 6th and final event of our semester that will be happening next week. So thank you again and have a nice weekend. Bye-bye.
Thanks. Let's keep in touch. Thank you. Thank you. Bye.